Kia ora tātou. Good morning and welcome to everyone. This is the 17th day of our hearings on Plan Change 7, and I'm pleased to announce that our first business this morning is the submission of the Ellesmere Sustainable Agriculture Incorporated, with which we associate Mrs. Carey Barnett, whom we welcome.
Tēnā koutou. Hello. As you've already said, I'm Mrs. Carey Barnett representing Ellesmere Sustainable Agriculture. Thank you for the opportunity to speak today and answer any questions you may have. I'll make a short introductory statement and then be happy to answer any questions. The group's main concerns with Plan Change 7 relate back to the minimal wider consultation undertaken prior to the notification of the omnibus provisions. We believe a number of issues apparent in the notified provisions could have been remedied or avoided prior to notification had constructive consultation taken place. Since the completion of Plan Change 1 in the Selwyn-Waihora zone and the significant consultation undertaken in that process, our focus has been on creating positive outcomes for farmers and the environment in our area. The promise of making actual improvements on the ground as opposed to continued concentration on further regulation. This focus has led to the group submitting 2 applications for funding from the Ministry of Primary Industries, both focused on riparian restoration, waterway improvement, and encouraging excellence in farming practice across our area. The Tanaku Germinate Growth Project has gained approval from MPI and will result in an excess of 2.5 million being spent on improvement works along our Ellesmere lowland streams, baseline waterway monitoring, and the creation of an environmental database for our area. It is a non-regulatory project that will involve not only our farmers, but close connections with the Selwyn District Council, ECAN, and Te Taumutu Runanga, and a variety of other interest groups, including local schools and the community. I am pleased to report that this project has also instigated our first official direct connection with Te Taumutu Runanga last week. Our group cannot express strongly enough the importance and success of non-regulatory activity and proactive consultation in supporting and improving environmental and farming outcomes. The group remains concerned that further regulation may hinder investment in environmental improvement on the ground. Thank you. I'm happy to answer questions.
Well, thank you very much for that introduction, Mrs. Barnett. We have read your full statement of evidence, of course, and very interested in a lot of its contents, in particular what you've touched on again in your introductory remarks, the cultural considerations that you've referred to, which we're all interested in. And in particular, also, there was what you've put under a different heading, which is Ngāi Tahu values. So we're interested in all of that and in the other important issues that you've raised, and thank you again. Do you have any questions for Mrs. Barnett, Commissioner Van Voorthuizen?
No questions, but I did read your submission with interest and note that you've raised a number of issues that other submitters have raised that we're certainly alive to, including, for instance, the definition of springs and the implications of that. So, yeah, a lot of the issues you raise have been raised consistently by others, so you can rest assured we'll be giving them some consideration. No questions or clarification, thanks.
Thank you.
Commissioner Solomon?
Yes, I do have a number of questions.
Yeah.
And I want to do this methodically and start with your paragraph 2.3 in your evidence in chief.
Yes.
Where you, because of your experience and expertise on ground truthing, good management practice and advising on FEPs or farm environment plans, I wonder if I could pose a question to you. In Miss Kylie Hall's evidence on behalf of Te Runanga o Arowhenua and Te Runanga o Ngaitahu at her paragraphs 81 to 83, she lists a number of misgivings with FEPs, including they're not statutory documents and no enforcement can be applied or to non-complying landowners, even though they acknowledge that non-complying landowners are for the most part in a minority. The content and quality and auditing of FEPs vary substantially depending on the author. The willingness of landowners to incorporate good management practices and the qualifications and expertise of the auditor, particularly with regard to cultural values, is not widely known. Protection of some cultural values requires a specialist understanding, which is not often held by farmers and farm auditors. Do you have any view on these misgivings?
We have a view overall that in our particular area, we find farm environment plans a very useful tool, and that it allows flexibility for a farmer to operate within something they have actually had a good input into themselves. It's a farm environment plan for their property. We've been really proactive in trying to engage with Runanga and getting them involved, and we're very supportive, as you know from reading my evidence, about engagement with Runanga and having an understanding of those values and trying to incorporate those into farm environment plans. I don't disagree, there's probably a lot more work to be done in that area, but I think that being proactive and doing it in a non-regulatory way via the farm environment plan is probably the best way to achieve that and to really invest and make changes on the ground in that sector. When I find our group would back that, and they would say that conversations and talking around these things and seeing how they work on site in the planning framework, but also in that hard to capture and regulate farming framework is the key to success of understanding and then addressing matters like mahinga kai values and other cultural values. One thing I would say is that, and that might not be clearly explained in our evidence, and it's hard to write in evidence, just like regulations, is that there's a lot to be said for talking and understanding and groups coming together. And I think, and I'm a firm believer, and I know our group will be as well, is that that's the best way to make change ahead. And after having our first shed talks meeting with Mananui Ramsden, we had a great turnout. It was very well received. A lot of people went away saying, now we actually understand what those values are, and we see the absolute value in doing riparian planting and making some subtle changes to what we do on the farm.
Interestingly, I've often thought that Runanga people and farmers are very similar because progress can be made faster if there is face-to-face talk. So I thank you for your response.
Sorry, but with respect, I don't want to interrupt your flow, but something I haven't said as well is that we actually believe in the family farming sector, that our care for the environment and understanding and wish to continue and better the environment that we've also farmed for a number of years is very similar to those values that Runanga have, because we also have that connection that Runanga have to land and water values.
Thank you for that. And now I want to get on to consultation, if you bear with me. At your paragraph 3.6, I appreciate your wanting to engage with Te Taumotu Runanga and their representative Mahanui Korotaio. And I'm not here to talk about why Te Taumotu didn't engage, because I don't know why. It's not my role for Taumotu. And the same for Mahanui Korotaio. My role doesn't need me to engage with them either. All I can do is acknowledge the efforts you've made to engage and sincerely apologise on their behalf for not engaging. I can, if you'd find it helpful, explain a little about why there may have been no engagement. But to do this, I have to provide some context, so if you'd bear with me, please, and I'll be as brief as I can. Taumotu, like all other runanga, receive numerous daily requests for engagement from organisations and individuals within their respective takiwā. For Taumotu, their takiwā lies between the Waimakariri in the north to the Hakatiri in the south, which is their area of authority or their mana whenua. The requests received are not only concerned with environmental matters, they cover a wide range of topics. Taumotu organises its work under a number of portfolios or work streams, where each portfolio consists of volunteers from the whānau, whose role is to consider the information staff put before them and make governance decisions on behalf of the runanga. A staff member is assigned to each portfolio, and the staff role is to facilitate, organise, collate and distribute the work that comes in specific to that portfolio, and after it's considered and decisions are made, staff then need to action their directions. Taumotu has 6 portfolios, and while each portfolio crosses over the other, they also operate independently. They have a hauora portfolio or a health portfolio, which covers health, education and justice. This means engaging with numerous schools, universities, several Crown Research Institutes, health and justice providers, all of which reside in their takiwā, so for them, Taumotu is their iwi. They have a ruahikihikitanga portfolio, which covers culture and identity and tikanga matters. For example, every time there is a request for an opening of a subdivision or precinct, or when a Māori name is requested, this portfolio takes the lead. Importantly, this portfolio directly benefits the whānau by organising and hosting wānanga, such as eeling, weaving, matariki, whakapapa, as well as tamariki days. And these wānanga occur every 2 or 3 months. This is an important portfolio because apart from the obvious, it directly benefits whānau and for much of the time is internally focused. We have a kaitiakitanga portfolio, or a portfolio that works with the environment. As you might appreciate, they have a very busy workload. Most development proposals, water takes, land use, discharge activities falls to this portfolio. This means engagement with 4 councils, Selwyn District, City Council, Ashburton and the Canterbury Regional Council. Not to mention DOC and Heritage New Zealand, research institutes, individual researchers and at times individuals. Mahanui Korotaio does do some of this work, but by no means all of it. They basically facilitate the consent responses and plan changes and advise dedicated members of this portfolio who then make the decisions. We have a Waihora portfolio. Waihora needs its own portfolio because it's a big lake with lots of issues, and so what they do is they help to manage the lake openings to comply with consent conditions. They work with government organisations, research institutes, DOC, CRC landowners to clean it up, support restoration initiatives and provide advice on managed retreat for sea level rise, for example. There's a Ngāti Muki Marae portfolio, and this is my area. As I project manage much of the work that's done at the marae, from installing a new wastewater system to upgrading and maintaining the marae facilities, preparing funding applications to several restoration projects on Waikikiwai and Papatahora within the immediate vicinity of the marae. The ideal place to start to make sure our own backyard is tidy before advocating to others about their backyards. There is also a sub-portfolio whose role is to look at future development of the marae in light of climate change and sea level rise. We also have a charitable trust whose role is to build the investment portfolio of the Runanga and fulfil its charitable purposes. Taumata employs 8 staff, of which 4 are part-time and 2 are marae-based, which is a cook and a facilities manager. So we are very much reliant on our volunteer whānau to assist with all the initiatives noted above. We couldn't do it without them, and staff are the only ones that get paid. We have an executive who are in the driver's seat, leading the monthly Runanga meetings and engaging directly with the whānau, reporting on and seeking directions and decisions at this governance forum. The executive, with the assistance of staff, provide feedback to local government on annual and long-term plans and maintain strategic relationships such as Ngāi Tahu, other Runanga, local and central government bodies. Te Taumata Runanga is answerable to potentially 24,000 people who all affiliate to Taumata. So we have to be strategic and smart in how we operate, and because any one of those 24,000 can quite rightly hold us to account, and believe me, they often do. And contrary to popular belief, we operate on a shoestring budget. And just for your information, Taumata has the largest amount of staff than any other Runanga. So you could say we're in a better position than every other Runanga. The requests for engagement have been coming in for a long time, which prompted the executive to issue a direction to staff to prioritise the work by using our strategic plan to guide the priorities, which is perhaps why Taumata has not responded to Ellesmere irrigation agriculture, which is no excuse. And again, I apologise, because they should have responded. It's simple good manners, even to acknowledge receipt of your request and explain why they haven't been able to give the time to engage. But be assured, when I'm able to, which will be some months away yet, I would definitely be telling them about this embarrassing situation. I feel embarrassed.
Oh, thank you.
So can I go on to your paragraph 33.7?
Yes.
I agree it's important that there should be a willing and open lines of communication between farmers and iwi within the CLMVA area. I wonder though how we could be strategic about it, given the stretched resources of Te Taumata and its priorities. Perhaps it needs a dedicated position, do you think? But I just wonder how we can resource that.
Yes. I think our evidence has suggested in the past that our group has actually given thought to appointing a cultural advisor, and at the time we were quite thankful for the appointment of Mananui Ramsden from ECAN's point of view, and at that stage we felt that perhaps we'll try and see how this goes, and that has been working really well, and we fully appreciate the workload that the Runanga is under, and we also appreciate the workload that Mananui Ramsden is under as well. So we definitely want to bridge the gap, and certainly what you've said this morning has reignited our positivity towards trying to come towards perhaps resourcing some person in a role that might be the go-between or offer some more engagement if we could. We've also suggested there's probably initiative that Selwyn District Council might follow up as well, where we're thinking about the potential for a rural advisor in that district council role, so bridging the gap between council and the rural community, but also seeing that there may be certainly a role there for cultural advice as well. So we're working on it, and we appreciate that it's also been recognised here today.
And can I go on to your paragraph 4.11?
Yes.
Just to change tack a little bit. I suggest the iwi or whānau will not want to put the details of wahi tapu or wahi taonga in a public document, even though there are some already in public documents. This is due to past indiscretions by non-Māori who fossickered and desecrated tapu sites in the past, and some still even do it today, even though it doesn't happen as often as it did in the past. I acknowledge that inconsistencies, time delays, increased costs, and the quality and costs of cultural assessments have led to your concern, and I accept this. We all know whānau and community people who have operated or operate still today without respect and integrity. So my question is, how can ESAI and iwi get a win-win from this provision?
I think certainly what we've just talked about, if providing a role where we can have open conversations works best, we find. So there is a non-regulatory aspect to it. Our suggestion is that, and the preference would be that we're quite clear as to what the values are, and that they're openly understood, I think, is the issue. And maybe that's what we need to do in our particular area as well. So where we've suggested here that whilst there's the indication that the reporting officer wants to address it as identified in this plan and relevant district plan or iwi management plan, that we've already illustrated the issues with that, and that you're talking about other documents that aren't actually relevant to this particular one, and that has a variety of changes there. But what I'm coming to is that I don't think there is any clear answer, to be honest, because the tangibility of some of the concerns that Runanga have around these issues are not easily written down. They're not easily put into words or regulation, much like farming operations. So I think it's two things: making sure that what the provisions are reasonably clear and what is being referred to. So if there's parts of the plan and the other rules and regulations and assessment matters that are not already covered, but Ngāi Tahu values see there as an addition to that, I think those values and the specifics of them probably need to be stated in the provision.
Yes, which leads me to my next question at paragraph 413. Regarding the sites of significance, I might agree it would be helpful if a general value description specific to each site were listed in a schedule in the LWRP. I could accept that. And with your paragraph 4.14, I'm not sure if I understand exactly what you're asking for. Are you asking that all values and sites of significance to Ngāi Tahu listed in the relevant district plans and IMPs are located in the LWRP? Because would that not, with what I've said about 4.13, satisfy that?
Yes, I think they need to be quite clear and reviewed as to where they are. we've found in the past that, and this is probably just a history thing and of time passing by, where it's hard to know exactly where the sites are in some cases, and in other cases we know that actually where this site is labelled is not in that place, it's actually somewhere else, but because of time, it's become uncertain where actually those locations are. So we do, and we think that is possibly a remedy, and we are concerned that there seems to be a trend of having large overlay shaded areas on maps as opposed to what has more traditionally been site-specific locations of particular sites of importance. So we see there's probably a combination of two things: to maybe reduce the large overlay areas to more specific spaces, but also where there is sites that are not necessarily there's the difference with the wāhi tapu sites are generally located in district plans, as are the tauanga sites. So then it's for Ngāi Tahu to have conversations with our group to say, well, there's other sites which we see of particular value, but we need to sort of hone down where those sites are, as opposed to doing the larger scale overlay. I think that's our main concern.
Yes.
Our worry for landholders is that they discover through a district plan or regional plan process that almost their entire property is now covered by a cultural value, and it's the first they become aware of it. And so our view is, okay, well, let's try and see if we can hone that down to some specifics, and maybe the area isn't quite as large as what it should be, and work through it that way. And I see that there's a lot of work that we can do and work with Runanga to try and bridge that gap and come to some suitable arrangement.
I think it would be very timely, because I think we're always evolving and moving on with knowledge. So I think we would, and I'm not here to speak on behalf of Te Taumotu, but I know that they would be ready for that conversation.
We definitely are. Yeah.
Okay, I have no further questions, thank you.
Okay, thank you.
Mrs. Barnett, coming back to the FEPs, which I think you were expressing some satisfaction with, I'm not sure whether a question that my colleague asked about them fairly put the whole position. I think there was a suggestion that they're non-statutory. And I don't know when that suggestion was put forward, but I certainly have the understanding that the statutory authority for them now. And so I don't want you to feel that we're putting a false position to you in a question. But do you find that in the situation that they are, as proposals under a land and water regional plan, with or without statutory authority, is that a satisfactory basis for them, or do you feel that they need some additional support, as it were?
I think in the situation that our group can report on is that they are quite a valuable tool, and we see that they have enough regulation around them. So most of the farmers in our area are either required to have a resource consent to farm, and as part of that, the condition of the resource consent requires them to have a farm environment plan. For those that don't require a consent, to which there are probably few, they are still required by the rules of the regional plan to have a farm environment plan, is my understanding. So we actually find them a useful tool, whether in a regulatory or non-regulatory context, because they help the farmer take ownership of what is happening on their property and check back that they are actually doing a good environmental job.
Well, thank you for that. Now, are any of your colleagues who are here to support you going to speak, or is that where we take it?
I'm sorry, I've actually gone it alone today, so the
That's
people
all right.
behind me are not our representatives.
Oh, I don't.
No.
Well, I can say that we've long learned to value your knowledge and your understanding and the clarity with which you can express the concerns of the ESA. And we thank you very much for attending this morning, and look forward to further contributions from you in the future. Thank you indeed, Mrs. Barnett.
Thank you, and we really appreciate the opportunity to come today, and we certainly appreciate those words from Mrs. Solomon. Thank you.
Now, our next business this morning is the submission of Rayoneir and Port Blakeley. Now, we have the original submission, and we have an evidence statement by Mr. Mann, together with annexures A to G and a summary, and we have an evidence statement by Mr. White.
Thank you and good morning, Commissioners. My name is Chris Fowler and I'm appearing as legal counsel for the submitter. Beside me is Meg Buddle of our office, and she's assisting me as counsel in this matter. And seated behind me to my left, Commissioners, is Darren Mann of Rayoneir Matariki Forests. And beside him, to his left, is Jerome Weymouth, a statutory planner.
Now, thank you for that introduction. I hadn't had any information that council were to be representing this submitter, and so I apologise for not calling on you in the right way, but I'm not familiar with you, so would you mind giving me again the names of council slowly so I can write it down?
Certainly, Commissioner. My name is Chris Fowler. Chris Fowler spelled Fowler.
Yes, thank you.
And beside me is Meg Buddle.
Buddle, is it?
Yeah, Buddle.
Thank you. Well, we're glad that you're here, and obviously you can take charge of managing the presentation of the submitter's case, and we'll be content with that.
Thank you, Commissioners. Perhaps I could check, first of all, that the Commissioners have documents that were filed last Thursday on behalf of these submitters, being a summary of evidence of Mr Mann and a summary of evidence for Mr Wyeth, and legal submissions filed by myself and Ms Butler.
Well, I certainly have the summary of Mr Mann. That's definitely here.
Yes.
I have just a moment. We have, of course, been flooded with a lot of documents in anticipation for this week, and perhaps I haven't been as efficient in filing them as I should have been. Well, I've definitely had and read Mr Mann's material that came in last week.
Yes, Commissioner, that was attached to the same email by which the other documents were lodged. If they're not readily available this morning, then we're happy to proceed on the basis that Mr Weymouth can read from his summary, if that will assist the Commissioners, and I'm very happy to walk you through a high-level overview of the legal submissions that I've lodged this morning also. And Ms Butler has just reminded me that we have hard copies of those documents available this morning, if that's going to be of assistance to any of the Commissioners.
That's splendid. Thank you very much. Well, you know what we've got. Probably my colleagues have the other documents that I'm missing, but it's fair that you should know what I have and what I don't have.
Thank you. That gives us a good starting point, and so perhaps I could then commence the discussion of the legal submissions that I've lodged. But first of all, make the point that the submission, the original submission, was lodged by two forestry companies, Commissioners, Port Blakeley Ltd and Rayoneir New Zealand Limited. Since then, that submission is supported by 4 other forestry companies that operate and are active here in the Canterbury region, and those companies are Allen Lorry Forestry Limited, WRRP Forestry Limited, PF Olsen Limited and Forest Management Limited. And those companies are referred to in my submission, Commissioners. As I mentioned, I have lodged full text submissions, but I don't propose to take you through those or I don't propose to read those, but I would like to highlight some of the key points, and that is that, first of all, the submission, the original submission, that is, raises a number of issues regarding rules 5.189 and 5.190 that seek to regulate plantation forestry activities, and I call those rules the PC7 forestry rules, Commissioners. The key issue now being pursued by the forestry submitters relates to the relationship between the Resource Management and National Environmental Standard for Plantation Forestry Regulations 2017, or the NES for Plantation PF, and the forestry rules proposed by the Regional Council. At my paragraph 14, I identify 3 key issues arising in this case, being first, Are the PC forestry rules more stringent than the comparable rules in the NESPF? Secondly, has ECAN provided sufficient evidence to justify the need for greater stringency in the circumstances of the Canterbury region? And thirdly, does the NPS FM 2020 affect the merits or availability of the relief sought by the forestry submitters? At my paragraph 16 to 21, I refer to the submission and relief sought by the forestry submitters, and the original submission lodged was quite broad, Commissioners, and the key point I want to make this morning is that the forestry submitters have narrowed the range of issues they seek to pursue at today's hearing, and hopefully that would have been evident from the evidence that's been lodged by the submitters. The case for the forestry submitters is focused on a narrow but we say important point regarding ECAN's Section 32 evaluation. The forestry submitters consider that evaluation is deficient because it fails to demonstrate that the more stringent forestry rules are necessary and justified in the context of the Canterbury region. On this basis, the forestry submitters seek that the PC7 forestry rules that are more stringent than the NES be removed from PC7, and the relevant rules are detailed at paragraph 20 of my full legal submissions. The submission in relation to afforestation and replanting within flow-sensitive catchments, that's regarding Rule 5.189 1 and 2, is not being pursued further because the relief sought by the forestry submitters has been adopted in the Section 42A officer report. Commissioners...
Just, let me interrupt just with that. The Section 42 report is a document that assists us, but it does not bind us. And I probably don't need to say more about that. I'm sure you understand what I'm saying. If it's your client's wish that we should adopt the recommendations in that report that you've referred to, you might as well say so.
And I will do that now, thank you, Commissioner.
Yes.
That would be my submission. And I'd also perhaps highlight that one of the reasons, a further reason why that issue or that rule is not being pursued is because, of course, the NES for plantation forestry doesn't seek to regulate a forestry with respect to water yield. And so the issue somewhat sits outside the scope of the thrust of the case that I'm presenting today.
Thank you.
Turning then to the NESPF itself, and included within that the sediment discharge regulations, in my submissions, I note that Mr. Weymouth, who's given evidence for the submitter, was closely involved in the development of the NESPF and supported its implementation by government officials. And at my paragraph 23, I include a quote, Commissioners, from Mr. Weymouth's evidence regarding the key driver or mischief that the NESPF seeks to address. Now, I typically wouldn't read that out because there would be a hard copy in front of you, Commissioners, but if you would find it of any assistance for me to read that section out, I'd be happy to do so.
Please, would you do that?
Certainly. So Mr. Weymouth considers that a key driver for the NESPF was to address unwanted variation across regions and districts in the management of plantation forestry under the RMA. This variation was creating significant operational and regulatory uncertainty for the forestry sector and leading to uncertain and inconsistent environmental outcomes.
Thank you.
And in my view, this is reflected in the policy objective of the NESPF, which is twofold, Commissioners. The first is to maintain or improve the environmental outcomes associated with plantation forestry activities nationally, and secondly, to increase the efficiency and certainty in the management of plantation forestry activities. Commissioners, and Mr. Weymouth's evidence provides a comprehensive overview of the NESPF, highlighting in particular the sediment regulation requirements and key points arising from his evidence and that overview include the range of forestry activities that are covered by the NESPF, the comprehensive and robust nature of the permitted activity standards contained within that document, the focus on managing sediment discharges from three key activities, Commissioners: earthworks, forestry, quarrying, and harvesting activities. And it does that by controlling and containing sediment runoff at source, and also by use of setbacks and management plans, erosion and sediment controls, and water quality mixing standards. And I make the submission that Mr. Weymouth's evidence, in my view, illustrates that the NESPF represents a paradigm shift in environmental management of plantation forestry activities, and it includes a particular focus on managing sediment and erosion at source using best practice forestry management practices. There is evidence before you regarding the efforts that's been made to ensure successful implementation of the NESPF, and in my view it is a considerable amount of effort that's been undertaken. That evidence is contained within the statement from Mr. Mann, and he refers to the work undertaken by the Ministry of Primary Industries, the New Zealand Forest Owners Association, and at the individual forestry company level, the work done by Rayoneir Matariki Forest to implement the NESPF. Mr. Mann also comments that the NESPF has raised the bar in terms of regulation of sediment and erosion control. And in my view, the sector generally, through the NZFOA and RMF or Rayoneir, has responded in a positive way to the need, for better and more management of sediment control, among other matters relating to forestry activities. And there is some evidence from Mr. Mann regarding compliance assessment that's been undertaken by ECAN of both Rayoneir and Port Blakeley, and those assessments show high levels of compliance, Commissioners. So the purpose of having provided some context regarding what the NESPF provides for, I'd like to mention briefly the legal relationship between national environmental standards and regional rules. I cover this in some detail in my legal submissions, but for today's purpose, I note that the RMA requires that regional councils that propose more stringent regional rules must explain why such rules are necessary in the particular circumstances of their region. Now, this requirement is founded in council's duties under Section 32 of the RMA, and specifically Section 32, subsection 4, and I've quoted that in full in my evidence, and if it would be helpful, I could read that out this morning.
Well, that's kind of you to offer, but for myself, I don't think you need to read out section 32.4 to me. I think I'm reasonably familiar with it. But
Yes.
I can't see whether my colleagues are indicating that they would like to hear it again.
They likewise are familiar with it, Commissioner. Thank you.
I think that's a fairly fundamental part of our job.
Absolutely.
Yes.
So I summarise the legal relationship at my paragraph 43 as follows. That regional rules that are more stringent than a national environmental standard are allowed, provided that such rules are expressly contemplated by the relevant standard and the Regional Council has completed an evaluation report under section 32 RMA that explains why greater stringency is justified in the particular circumstances of the region. And in my view, this latter requirement centred around the section 32 assessment imposes an important constraint on the power of regional councils to promulgate rules that are more stringent than a national environmental standard and supports the hierarchy of planning instruments provided by the RMA. Commissioners, there's a paucity of case law in relation to the NESPF and its relationship with regional rules, and that's not surprising given the relative infancy of the NESPF. However, there is a decision, the recent Commissioner's decision on a proposed plan change 1 to the Waikato Regional Plan, or PC1, which I'd like to refer you to. The decision is of interest as it deals with a similar fact situation regarding the relationship between regional forestry rules and the NSPF regulations. In that case, provisions were notified intending to manage nutrient discharges within the Waikato region, and submitters sought to introduce additional rules that would control plantation forestry activities, and foresters responded by pointing to the fact that there was no comparison between what the NS provided for and these additional rules that were being sought by submitters, and their view was there was insufficient justification to support greater stringency than what was already provided for in the NES-PF. And the PC1 decision highlights the importance of evidential support for regional rules that are more stringent than the NES, and my submissions include a couple of quotes from the Commissioner's decision. The first is perhaps of more interest. I'm happy to read that, or you could look at it later if you wish, Commissioners.
Well, we'll do better with it if you leave it with us, and we can study it and give it the attention that it deserves.
Yes, certainly, and the extract is from that decision is lodged with my submissions. I hasten to add, Commissioners, that the PC1 decision, of course, doesn't create a legal precedent. It's not binding on you, of course, but I have included it and referred to it because I think it may be of assistance to you. I want to speak briefly about the comparison between the PC7 forestry rules and the NS provisions. And these matters are covered in some detail in Mr. Wyeth's evidence, where he includes a high-level assessment of the PC forestry rules against the corresponding regulations in the NSPF, and he concludes that nearly all standards, most of which have been rolled over from the Canterbury Land and Water Regional Plan, are more stringent than the NSPF. I also want to discuss the justification provided by ECAN for the PC7 forestry rules. And this is also covered in my submissions, my written submissions. And the starting point is the forestry submitters accept that ECAN does have jurisdiction to propose rules that are more stringent than the NESPF in the circumstances of this case, because Regulation 6 of the NESPF allows for more stringent rules where they're intended to give effect to a regional objective that in itself gives effect to a freshwater objective. However, in my view, justification jurisdiction of itself is not sufficient. ECAN is also required to justify the need for greater stringency than the NESPF, and the key issue arising in this case is whether sufficient justification has been provided by ECAN for the greater stringency. And in that regard, the two relevant documents are the Section 32 report and the PC7 Section 42A report. And these documents have been assessed by Mr. Wyeth, and in his evidence, he finds that...
The start in a particular position of his evidence statement.
So
I have it in front of me, and
oh, yes. So
which paragraph are we at?
I believe it's paragraphs. Just check that. Paragraphs 43 and 44.
Ah, right, thank you.
And also, Commissioner, at paragraphs 65 and 68.
Thank you. Some of that looks at first glance to be, or second glance, to be as much legal submissions as evidence.
I'll let you be the judge of that, Commissioner. But I think that what Mr. Weymouth has done is a comparison, a fair comparison between the two, and he has reached some findings in relation to that, to his comparison.
Thank you.
Mr. Wyeth, I should say, also undertakes an assessment of the Section 42A report, and whether that document contains a response to the forester's submission as to the lack of justification for greater stringency, and based on Mr. Wyeth's evidence, my view is that the deficiencies in the Section 32 report that Mr. Wyeth has identified are not cured by the Section 42A officer report.
Thank you.
Commissioners, in my submission, the omission to identify the NSPF as a reasonably practicable option in the Section 32 report is central to the failings of the assessment, because this, in my view, appears to have led to other shortcomings identified by Mr. Wyeth, including a failure to undertake an assessment of, first, the adequacy of the NSPF to manage the effects of plantation forestry in the Canterbury region. Secondly, an assessment of regionally specific factors and values that might justify more stringent rules. And thirdly, the economic cost to plantation forest owners and managers associated with the more stringent provisions of PC7. And in my submission, in the absence of an assessment of these matters, it's virtually impossible to assess the efficiency and effectiveness of the PC forestry rules in achieving the objectives of the Canterbury Land and Water Regional Plan as required by the relevant provisions of Section 32 RMA. And I'd also add, Commissioners, that the absence of a meaningful or robust assessment of the benefits and costs of the PC forestry rules against comparable NSPF rules or provisions is noteworthy. And Mr. Mann's evidence includes some comments on the difficulties that the current situation creates at an operational level for plantation foresters. And he refers, among other matters, to the uncertainty as to how PC7 rules align with the NSPF, uncertainty around how compliance with PC sediment discharge rules will be measured and assessed in the forest. And his evidence highlights the wide scope of application of the suspended sediment standard in PC7 forestry rules as compared to the more targeted approach that's provided for in the NSPF. So these things are important in my view because they create potential for significant additional costs to the plantation forestry companies in the Canterbury region. And these are over and above the cost they're already incurring as they seek to implement the NSPF without any apparent environmental benefit. Commissioners, that sort of completes my comments in relation to the, what I'll call the Section 32, argument. Since the original submission was filed, of course, the NPS Freshwater Management 2020 has come into play, and my legal submissions provide some comment on the implications of that as it relates to the case for the plantation forestry submitters, and I'd like to make some comments on that as well.
Thank you.
In my view, the hearings panel must endeavour to give effect to the NPS Freshwater Management 2020 when making decisions on the PC7 forestry rules to the extent that it's reasonably practicable to do so. I've read the opening submissions by my friend for the Regional Council and the cases that he refers to therein in relation to this matter, and there's not a great deal of difference between us as to the legal principles in play. It seems to me that the panel must undertake an evaluative exercise when determining the extent to which it's able in a practical way to implement the NSPF in the context of the PC7 forestry rules. And in my view, there are three practical constraints and some other factors that ought to have a bearing on the panel's consideration, because, and I highlight these matters because it seems to me that each case will, if the legal principles are fairly well understood, each case is going to turn on its particular facts. And the constraints that I refer to in my submissions are first that there are significant and quite detailed implementation steps that need to be completed by ECAN to give full effect to the MPS FM 2020. The document, in terms of implementation, is contains significant differences of approach from the earlier NPS. Some of those are quite demanding. And it's challenging to understand how the panel can meaningfully implement the NPS without the benefit of the data and the consultation and the other steps that ECAN is required to undertake as part of the implementation of the NPS. Another constraint, Commissioners, is the scope constraints, because we're here partway through a hearing process and there are some obvious limitations in terms of the nature of changes that the panel is able to make due to the limits of the submissions that have been received on PC7. And finally, the requirement at section 32(4), which I've already referred to justify greater stringency than the NESPF. And in my view, that requirement remains very real and highly relevant. And so not only does the panel need to undertake take into account questions of scope and the implementation, but it also needs to have evidence in front of it as to a comparison of any changes it might wish to make to implement the NPS with the provisions that are already contained within the NES to determine whether any greater stringency is actually needed to implement the NPS Freshwater Management 2020 in the context of the Canterbury region. So there is, in my view, a fairly considerable gap between the notified provisions of PC7 forestry rules and what is actually contemplated in the new NPS. And it's challenging, in my view, for the panel to bridge that gap within the constraints of the PC7 submission process. And what I'm submitting to you today is that an alternative approach of allowing an alternative approach which I think is better, and that alternative approach is to simply take the PC7 forestry rules out of the out of PC7 and allow the NESPF forestry provisions to prevail and be the primary source of regulation of forestry activities within the Canterbury region until such time as the work anticipated by the NPS for freshwater management is completed, and if that work demonstrates that there are shortcomings within the circumstances of the Canterbury region in the NESPF, then at that point appropriate rules could be notified by the regional council, and of course those rules would be supported by the necessary an appropriate Section 32 assessment to justify those more stringent rules. And the other point I'd highlight, Commissioners, is that the approach that I'm here suggesting or proposing is focused only on the PC7 forestry rules, and this section of PC7 is different from the other parts of PC7 because it's only these rules that are influenced by the NES for plantation forestry. So if you're minded to adopt the approach that I'm proposing, it's not as though there's going to be a vacuum or a gap in regulation of plantation forestry activities as they might relate or affect the in-stream values of water quality. Those provisions, there's already a significant suite of controls managing the potential adverse effects of plantation forestry contained within the NESPF. And I'd direct you toward the evidence of Mr. Weymouth, which discusses those in some detail. So overall, in my view, there are some sound practical reasons why the NPS-FM 2020 cannot be given effect to via submissions on the PC7 forestry rules. In our submission, the appropriate approach in the circumstances is for ECAN to prepare a comprehensive plan change to give effect to the NPS-FM 2020, and that would allow ECAN to complete the required implementation steps, undertake a robust Section 32 assessment prior to notification of any new rules affecting plantation forestry activities. Finally, I'd say just on this point that there is some commentary around the NPS-FM within the supplementary, within the summary of evidence provided by Mr. Weymouth, which you may have had an opportunity to read prior to the hearing, but you'll hear from, and he'll be available to answer any questions on that point today, Commissioners. So that completes the submissions for the forestry submitters, and I'm happy to take any questions.
Commissioner Van Voorthuizen, do you have any questions to ask of Council?
No questions for the legal submissions. I have a number of questions for Mr. Weymouth when we come to him, but I'll wait for them.
Thank you. Commissioner Solomon?
No questions from me either. Thank you.
Mr. Fowler, I do apologise that I hadn't somehow or other managed to be able to read your script of your submissions in advance, but I've followed it and made many notes, and I'm grateful to you for them. And I will, of course, get the text in due course.
Thank you.
So, would you like to proceed now to one of the witnesses?
Yes, I would. I'd like you to hear from Darren Mann first of all. I'll ask him to present his summary, Commissioner.
Thank you. Just a moment.
Good morning, Commissioners.
Good morning, Mr. Mann, and welcome. Thank you.
Thank you.
Thank you for just the summary.
My mic's working, that's great. I prepared a summary just to talk through. It takes just about 15 minutes. I timed myself last night. But look, my name's Darren Mann. I'm the General Manager for Rayoneir Matariki for our New Zealand operations. I'm based in our office at Rayoneir. And my qualifications and experience are outlined in that evidence in chief. And perhaps just to put some context around Rayoneir Matariki, we're a forestry company that operates across several regions in New Zealand, about 120,000 hectares, and in Canterbury, of that, we have about 24,000 net stocked hectares. So that just puts a bit of context, I guess, around our scale of our business. I repeat and so from now on I'll just refer to Rayoneir Matariki as RMF. I repeat the confirmation that I've read the Code of Conduct for expert witnesses and that my evidence has been prepared in compliance with that code. My evidence in chief addressed the following. A, the forestry sector response to the introduction of the National Environmental Standards for Plantation Forestry, the NESPF. RMF's approach to management of sediment discharges under the NESPF within the Canterbury region. RMF's costs arising from compliance costs with the NES sediment discharge regulations, and finally, additional costs and uncertainty caused by Plan Change 7 sediment discharge rules for forestry companies and related businesses within the Canterbury region. This is a summary of the key issues raised in that evidence in chief, and there are extensive annexures that you referred to before, which set out in breadth the information documentation that provides for and supports the implementation of the NES. So the summary of key issues, the forestry sector response to the NESPF. After a 6-month lead-in time, the commence...
Pause a moment, Mr.
Sure.
Mann. Just pause a moment if you would. Mr. Fowler, what Mr. Mann is reading to us, we already have had in script and have read. Of course, if you wish that he should read it to us, that's your choice and we accept it. But if you don't think it's necessary for him to read it, if you accept that we have already read it, as we have, then you may feel there's some other way in which you'd like to proceed, but I'll leave it to you. I just want you to know that we have already read it, we have the text in front of us, and you can proceed with that as you choose.
Thank you, Commissioner. I'll just converse with Mr. Mann.
Yes.
So thank you. Appreciate that you've read it. What I've just suggested to Chris is perhaps we just shift straight to page 5,
Yes,
which is essentially the second to last page, and that just spells out some concerns that I've got, and really just summarises the final point. So just from the top of page 5, additional
Yes.
costs and uncertainty caused by Plan Change 7 sediment discharge rules for forestry companies and related businesses within the Canterbury region. So it's concern to me that Plan Change 7 was not discussed with RMF or other forestry companies, to my knowledge, within the Canterbury region before it was notified. There has also been no discussion with RMF or other companies, to my knowledge, about how the NES has changed forestry operations and in particular the control of erosion and sediment. It's unclear to me how Plan Change 7 will align with the NES. I'm not sure if the NES regime of land use rules will continue, or if the only matter that has to be complied with is the Plan Change 7 discharge rule. Excuse me. I'm not sure when and where and how compliance under Plan Change 7 is going to be measured or achieved. Of concern is how diffuse discharges of sediment is going to be monitored. It is also of concern that monitoring will have to be undertaken in rain events, and I'm not sure if such monitoring could actually be undertaken safely on every site. It appears that the RMF forests with no harvesting or earthwork construction occurring will be subject to meeting the proposed discharge rule. My greatest concern is the wide scope of application of the suspended sediment standard to all rivers in a forest of any soil type, not just highly erodible soils, and in any rain event. Given the lack of evidence as to where, when and how the suspended sediment standard will be measured, I'm not clear if RMF can comply with the Plan Change 7 sediment discharge rule at all times. This is despite the increased activity controls of the NES and the change in environmental management and operations introduced by not only RMF but other forestry companies as well since the NES came into force. Plan Change 7 suspended sediment standard is not based on consideration of particular catchments and values attributes for a catchment. There is no consideration of the existing background levels of the various catchments in Canterbury, and in my evidence in chief I referred to RMF work being undertaken for a sediment discharge consent in Omahi Forest And just as an update, the RMF monitoring, the monitoring that we're doing is providing the existing bottom line for suspended sediment. There's no in-stream data existing with ECAN at the moment. The monitoring confirms that catchments in Omahi Forest where there is no forestry activity are already very close to, and in some cases exceed, the suspended sediment standard of Plan Change 7. So that's with no operations occurring. The ecology study that, which has now cost about $40,000, indicates that the ecological values for the various catchments are highly variable. And I'd also just like to take this moment to amend a statement in my evidence in chief. The statement read that all of Omahi Forest, 1,334 hectares, was categorised in the orange zone under the ESC classification system. It was in fact just the Teviotdale block in Omahi Forest, which comprises 577 hectares, and this affects points 26, 65 and 66 in that evidence. So at this stage it's not clear what monitoring conditions and operational conditions would be applied, assuming consent is granted. Of concern is if harvesting would have to stop in rain events, leading to uncertainty in harvest operations and wood supply in the Canterbury region. 70% of the harvest from our forests in Canterbury is supplied to local sawmills and an MDF plant. Just over 50% of the wood received by these local wood processors actually comes from the RMF estate. Certainty of harvest is therefore very important to the local wood processing facilities. Overall, it's difficult to put an exact figure on the additional costs for RMF and other businesses arising from the Plan Change 7 sediment discharge rules. However, for the reasons discussed above, it is clear to me that the costs would increase under that plan change. So just concluding, RMF supports the NES for plantation forestry, even though it imposes greater controls on forestry operations. The NES provides a certainty to RMF's ability to operate. The Plan Change 7 rules are a significant departure from the NES, and the Plan Change 7 rules have been produced with little explanation as to why they are necessary after the introduction of new and extensive provisions of the NES. So overall, the outcome that I seek is that the Plan Change 7 discharge rules are deleted and that ECAN works with the forest industry to assess the effectiveness of the NES and in protecting water body environments in Canterbury. Thank you.
Well, thank you very much for that summary, Mr. Mann, and indeed for the fully detailed original evidence statement. Let's see if there are questions for you. Commissioner Van Voorthuizen?
No questions for Mr. Mann, thank you.
Commissioner Solomon?
No questions from me either, thank you.
Well, to understand that we do value the way in which you've presented your evidence, Mr. Mann, and we're grateful to you.
Thank you.
Commissioners, the next witness for the submitter is Jerome Wyeth.
I'm just wondering whether you feel this is perhaps a good opportunity for us to take a morning adjournment, and then we won't need to interrupt Mr. Wyeth once he's got going.
Good idea, Commissioner.
Quarter of an hour, and then we'll resume and take Mr. Wyeth's evidence.
Thank you.
Well, I think we can resume now, and Mr. Fowler, we could come to Mr. Wyeth's evidence if that's convenient.
Yes, thank you, Commissioner.
Good morning, Commissioners. Obviously, you have in front of you my evidence in chief and my summary evidence, and Mr. Fowler has covered some of the key points from both of those. So I could either sort of walk through my summary, or if it's more appropriate for you, I can just highlight a couple of key points and allow more time for questions.
Well, we're not wanting to cut you short. We do want to have what you would like to present to us, and I'm grateful that you've taken the care with your summary, and I'm sure that covers the main points, and just present them to us as you would like.
Okay, thanks. Okay, so in terms of what I'd like to cover in my summary, I'm really just going to focus on the circumstances where plan rules can be more stringent than the NESPF. the requirements to demonstrate that more stringent rules are justified in the context of a particular region, and whether sufficient justification has been provided in PC7 and the associated statutory documents. And I'll also touch on some of the implications of the recently enacted MPS FM 2020. So as you'll be aware, the NES, I'll just refer to it as the NES, was gazetted in 2017, came into force on 1st May 2018. A key driver for the NES was to address unwarranted variation in the management of plantation forestry across regional and district plans. It was an extensive process developed over 8 years. It involved numerous stakeholders, including the forestry industry, regional councils, district councils, and environmental groups. The hierarchy of the RMA is that NES generally prevail over district plan rules, unless the NES expressly states otherwise. So the NESPF generally takes precedence over regional district plan rules, with some limited exceptions. And this is fundamental to the overall objective of the NES, which is to increase the efficiency and certainty of the management of plantation forestry, while also maintaining or improving environmental outcomes. And as touched on in my evidence in chief, there are numerous regulations throughout the NES relating to the management of sediment. The key focus there is that it's really a sort of more pragmatic approach, which is around controlling and containing sediment runoff at source and ensuring there are appropriate setbacks to water bodies. So in terms of the circumstances when plan rules can be more stringent, this is obviously, it was a carefully considered aspect of the NES when it was being developed. And the circumstances there are quite specific. They really relate to when you're given effect to other national direction or other matters of national importance in terms of Section 6 of the RMA. So of particular relevance to the PC7 forestry rules is obviously Regulation 6.1a, which states that a plan rule may be more stringent than regulations if the rule gives effect to an objective developed to give effect to the MPS FM. Within those circumstances, councils are also required to demonstrate that a more stringent rule is justified in the context of a particular region or district. In my view, these are important statutory requirements in the context of the consideration of PC7 forestry rules. Statutory requirements and good planning practice both emphasise the need to exercise stringency over NES in a very considered and transparent manner. This reflects the hierarchy of planning instruments under the RMA and the general purpose of NES from my view, which is to provide nationally consistency and certainty on significant resource management issues. I won't sort of touch on the relationship too much between the PC7 rules and NES, rather than just to say from the sort of high-level assessment I did, there's a number of aspects where they would be more stringent than the NES, and they're quite different in nature in terms of how they operate. One's a sort of more of a, I guess, an absolute standard that applies largely region-wide, where the NES is based more on a sort of more pragmatic, site-specific management approach based on good management practices. So I guess the key aspect of the argument here is, has there been sufficient justification in terms of the requirements under Regulation 6 of the NES and Section 32.4 of the RMA through PC7 statutory documents and Section 32 in particular. And I have sort of assessed the approach that ECAN has gone about justifying the more stringent rules in PC7 through the Section 32 evaluation. And essentially, you know, my take from it is I've essentially looked at what's more stringent, related those in the existing provisions, related those to existing objectives, and then sort of included a stringency justification statement where these provisions collectively represent the provisions that are more stringent than the NES and are necessary to achieve freshwater objectives. So in effect, they've essentially rolled over the more stringent provisions without looking at the appropriateness of those in light of the NES. And in my view, that's not sufficient without undertaking that assessment of whether those more stringent provisions are necessary in the context of the particular region, and that the NES is deficient in that regard. So I guess the key point here is that, you know, Regulation 6 in itself does not justify more stringency. It just allows for more stringency in site-specific circumstances when it's warranted. So it sort of recognises that you may need to be more stringent to give effect to the MPSFM, but that's only in specific circumstances. It's not just a general sort of blanket ability to be more stringent. There is obviously an absence of case law that I'm aware on section 32.4, but I think, and what would reflect good planning practice in this situation is that would involve an assessment of the adequacy of the MPS to achieve those plan objectives in the first instance. So the NES is the starting point, and then on top of that, whether there's regionally or catchment specific factors that may warrant a more stringent approach, and that may be particular sensitive catchments, or where the community has identified that they want a significant improvement in freshwater values, for example. And in my opinion, the Section 32 evaluation for PC7 does not adequately meet these requirements. For example, there's no assessment of the adequacy of the NES to manage plantation forestry in the region. There's also no assessment of the effectiveness and efficiency of the more stringent approach compared to the NES. As was touched on, that was not identified as a reasonable practicable option, and in my view it should almost be that the NES is the starting point and other options are assessed against the NES, and certainly not that the NES should be admitted as a reasonable practical option to be assessed as part of the Section 32 evaluation. So overall, in my opinion, the lack of consideration of these factors is inconsistent with good planning practice and arguably fails to meet the requirements of Section 32.4 of the RMA. That's sort of all I was going to touch on in terms of the sort of stringency argument. I will just make a couple of points in relation to the implications of the MPSFM that has been recently enacted. And I guess the key thing there is that what the MPSFM has done is introduced 2 new sediment attributes, and these were, as I touched on in my evidence in chief, in development while the NES-PF was being developed. So that's why there's more of a reference to the general water quality standards in the Section 70 of the RMA. But I guess, as you'll all be familiar, the requirement to give effect to the MPSFM is quite a detailed sort of process that will require identification of values and setting attribute states for sediment in relation to those values for all FMUs within the Canterbury region. And that will be quite an extensive process, obviously, that will involve engagement with the community and tangata whenua, and I don't think it's obviously practicable to give effect to the MPSFM in full in relation to sediment through this process. So I guess then the question is, what is the most effective and efficient approach to manage sediment from plantation forestry in this interim period that gives effect to the MPSFM to the extent practicable in these circumstances and is consistent with the requirements of Section 32.4 of the RMA. Obviously, so there's a new objective that you'll be aware of in the MPSFM that sets out a bit of a prioritisation around first the health and well-being of water bodies and freshwater ecosystems.
Yes, you can be sure that we're well aware of that.
Okay. I guess, I just wanted to say it's outside the scope for me to do a detailed assessment of the NES-PF against the new provisions that have come in the MPS FM 20. But just to say that, based on my understanding of the NES and, how the process that was developed and to develop the comprehensive set of regulations that are designed to maintain or improve environmental outcomes, I would argue that it's at least consistent with that objective. And in my opinion, given some of the limitations around the justification of the more stringent provisions in PC7, may well be a more efficient and effective approach to rely on for the NES to continue to operate as it is doing in the Canterbury region, and then allow to a more detailed sort of process to go through and then identify whether more stringent rules are justified in light of the new requirements in the MPSFM. Thank you.
Well, thank you, Mr. Wyatt. That's a very, very focused summary of what we have in your some 80 paragraphs, and I'm not suggesting that's too long, but but in your original evidence statement, it's fully presented, and you've given a good summary of it, and in particular also reminded us of the effects of the NPS FM 20, which is of course since you wrote the original evidence. Questions for Mr. Wyatt? Commissioner Van Voorthuizen?
Yes, a number of questions. So I certainly understand the thrust of your case before us now is to avoid any overlap between Rule 5.189 and the NESPF unless that overlap is justified and warranted in the circumstances of the region. So what I want to do is walk you through the provisions of 5.189 that you still have a concern about. So do you have a copy of the 10 July 2020 consolidated version of the Section 42A recommended changes to the provisions?
No, I don't have that hand, sorry.
Can we provide that to the witness, please?
Thank you.
So I'll just give you a moment to find Rule 5.189. Not sure what page it's on. Yep, and then a copy of your evidence in chief, which I'll refer to, and possibly a copy of the NESPF. Do you have that with you?
I'm sorry. I thought I was well prepared.
Yeah, good. All right, so if we turn to Rule 5.189, appreciate that you've accepted conditions 1 and 2 already, so I won't deal with those. So I'll start with condition 3. So I understand the concern you've expressed about the TSS numerics, and you're not alone in expressing a concern in that regard, either in terms of this region or others.
Yep.
So if I turn to your evidence in chief, and I start with paragraph 30, which is on page 10, and you helpfully there, sorry, just wait till you get it, you refer to the water quality standards that are in the NESPF, and I note A is any conspicuous change in colour or visual clarity. And then I noted with interest down at your paragraph 33, you have the bold heading water quality mixing standards, and I read with interest the last part of the paragraph in italics, which is that regional councils will apply more specificity to these standards using their existing practices and guidelines, and this will help maintain or improve water quality. So thinking about that, a thought I had was with regard to condition 3 of Rule 5.189, a suggestion that if, and this is only a suggestion, of course, that if we were to remove the TSS numerics, but retain a reference to Schedule 5 of the Land and Water Regional Plan, which provides quite more specific guidance on visual clarity, whether or not that would be an appropriate solution in terms of the submitter's concerns.
That would certainly be in line with the intent of the NESPF, and I think I'm pretty sure I made a comment on that in my assessment of the...
Okay. All right.
If I just... Yeah, if you go to page, on paragraph 60 of my evidence in chief, I talk about the numeric TSS limit, and you've got it. Thanks.
What paragraph was that?
Oh, 60, sorry. And I sort of say, conversely, there, the requirement to comply with the visual clarity standard in Schedule 5 is consistent with that anticipated under the NES.
Okay, so that would be a reasonable solution. Dealing now with conditions 4 and 5, if I turn to paragraph 14 of your evidence in chief, get my computer to work. And so I noticed just above paragraph 14 in italics again, you reference the fish spawning indicator, which is incorporated by reference into the NESPF. So my question is, have you done an analysis to determine if there's any overlap between the results of the fish spawning indicator and the Rule 5.189 IFSH, or critical habitat areas, and the inanga spawning habitat areas?
The answer is no, I have not done that detailed assessment.
Okay, so we don't know if any further specificity is warranted in that regard. So it might be safe for us to assume that it's useful to keep those provisions in. So the next one is condition 6. Not a question, but I certainly understand the concern about potential overlap here, because looking at the NESPF, I mean, regulations 13.3, 29, 54.3, 74.8, etc., all provide quite reasonable buffer distances from wetlands bigger than 0.25 hectares for forestation, earthworks, quarrying, etc., mechanical land preparation. So I understand why you might be concerned that there's unnecessary overlap with that condition, but not a question. So I just understand the point being made, if I've interpreted it correctly. Which brings us to the last condition, condition 7. Now I note NESPF regulation 104 deals with fuel storage and refuelling, but there don't seem to be any other references in the NES to hazardous substances in general that I could find. Are there any?
No, not that I'm aware of.
So the overlap is obviously with fuel refueling, with refueling and storage of fuel, but there might not be an overlap in terms of hazardous substances generally. Okay. All right, that's all I wanted to clarify with you. Thanks very much for that.
Commissioner Solomon?
Yes, I just have one, and it's regarding rock art sites. Does RMF have any forests near the rock art sites, which are located in Kaikoura, South Canterbury, North Otago, North Canterbury, the Upper Waitaki and Ōpihi catchments, Central Otago and Murihiku?
Sorry, what material?
Sorry, I'm not familiar with those sites. Are they a culturally significant site or a...
Yes, well, they would fall under Section 6E, nationally significant, nationally important sites.
Yes.
And they are outlined in the Ngaitahu evidence under Miss Simon's evidence. She's got a map that shows where the rock art sites are, and it's in her Appendix B. I think it's on page 4, and the appendix is titled Guideline for Implementing a Land-Based Taonga Risk and Vulnerability Assessment in the Context of Freshwater Environments. Their concerns are around, rock art is particularly vulnerable to hydrological changes such as irrigation, groundwater abstraction, drainage diversions, water conveyance and other excavation activities. And actually, Ngaitahu seek more stringent rules. I just wondered, does the NEPS or NESPF have any provisions in it that protect cultural values such as rock art?
The answer is no, but they are a FEC that is not addressed. Culturally significant sites and heritage sites were specifically excluded as an effect addressed in the NES, which enables plan rules to still address that effect. So those existing provisions relating to those sites and existing plans should continue to prevail, but the NES doesn't include any specific provisions around those sites.
So because they are included in the PC7, your operations would naturally abide by those protection mechanisms?
They would need to apply, yes, that's my understanding.
Thank you, you've answered my question.
Thanks.
Thank you, Mr. Blythe.
Thank you.
We've had the benefit of your full and careful presentation. Thank you for that.
Thank you.
Thank you, Commissioner. Unless you have any further questions, that completes the case for the submitters.
Well, thank you, Mr. Fowler. I don't have any further questions that I'm going to be addressing to you. I'm sorry that I didn't have the pre-reading of your submissions that I should have had, but that's just what's happened. And you've covered it well, and we're grateful to you. Thank you.
You're welcome. Thank you.
Is the next item on our agenda for this morning Wainono Dairy?
Thank you. I'm Richard Green,
Good
representing...
morning, Mr. Green. Well, it's just afternoon, I think.
Just afternoon.
It's good to meet you. Thank you for coming in. And we have, of course, your original submission, and we have your evidence statement, and we now welcome you speaking to that.
Great, and thanks for the opportunity to do so. It's a huge commitment of time you're all making, but it's very important to us as farmers. But I think you probably won't hear anything new from me that you haven't heard before, but perhaps from a slightly different angle. So
that's what we look forward to. Your own experience and your own concerns.
great, thank you. So Wainono Dairy Ltd is actually an equity partnership that I'll explain, but we were formed some 14 years ago by 3 families. And just so a sense of location, our main farming business is just right adjacent to the Fairlie township, for those that I'm sure you've been through there, just on the Timaru side of the Fairlie township, adjoining the Opahi River for about 5 kilometres actually. And we've also got support blocks above Fairlie against the base of the hill. So we're part of the upper Opahi catchment. So my partners, John and Sarah Wright, moved down from Central Otago back in 1999, so 21 years ago. And they've been farming there ever since and raised their 4 children in the district and very actively involved in the Fairlie community. The Wrights were originally attracted to Fairlie given the range of farming opportunities that were available there, from the new and reliable irrigation water from the Apua Dam development, which has been huge for this district. The Wrights quickly realised that to optimise the return from that water, they couldn't just treat it as a drought buffer like we used to. They actually had to invest in a way to optimise the return from that water. So to finance that, they actually needed to do the scary thing of bringing in some unknown equity partners in to help them do that. And at the time, this was an extremely brave step, but they passionately believed in the opportunities that this would provide their family. So I met the Wrights back in the mid-2000s, and myself and my cousin actually invested alongside the Wrights at this time, and some 14 and a half years ago, and we've never looked back. So we're effectively 3 shareholding families that are part of Wainono, and we're actually exceptionally proud of the business we've developed and the financial and the social contribution we've made to the Fairlie district. We actually all appreciate that our combined capital and individual skills we bring mean that we've achieved far more together than we ever could alone. So it's a great model and one I encourage to a lot of other people. We currently employ about 15 full-time staff within our business, and we actually lease land off 6 neighbours, all within a 5-kilometre region of our dairy platform. John Wright runs the business day to day, and as such he's constantly juggling the ongoing demands that farmers have between cows, grass, staff, the regulators, the bankers, and also a commitment back to the community and social licence to the community. John, and I can say it here, he's not here, but he's a very talented farmer, and he gets a high level performance from the property, and that has allowed us to keep expanding the business over the past 14 years. John should be here today, not myself speaking, but he'd prefer to be dealing with cows and grass and issues back on the farm. And I'm actually, I guess, the chairman of the board in theory. And basically that means I do everything that John doesn't want to do. So Wainono Dairy over the past 14 years has actually perfected the art of making a small amount of water go a long way. So in total we use about 185 litres of water per second for a 100 to 130 day irrigation season across 537 hectares of irrigation. And that actually means we've got 3.2 mils of irrigation water per hectare per day, which is significantly below other regions. And you take Canterbury, for example, that's geared to more between 4 and 5 mils. But it's actually due to a combination of good soils, lower evapotranspiration in the Fairlie Basin, we've got on-farm water storage, but we also are active users of technology. But operating at the edge with water efficiency means that any change of the reliability of our irrigation water does have a significant impact on our business. So we've been a very active part of the community group, the FAWP, that worked with ECAN around minimum flows in the upper Opahi River. And after considerable discussion in our own financial modelling, we supported the proposed stage 1 lift in minimum flows from 790 to 850 litres per second. We know we'd have to adapt our farming system to adjust to this, but we also know that the implications of this financially are relatively minor. But we do appreciate that everyone does need to make compromise, because the health of the river is absolutely critical for everyone who lives in our community. And the science advice from our environmental scientist, Dr. Ryder, was that the proposed stage 1 levels, minimum flow levels in our river, would provide excellent habitat for most aquatic species over the warm summer months, which is obviously what we're talking about. But I guess our submission strongly opposes the further proposed stage 2 minimum flow restrictions contained in PC7, where it's obviously lifting that to 1,000 litres per second in 2025. Grant Porter actually modelled on our farm, and he's presented as evidence, but he modelled on our farm the economic impact across our business. And assuming the number of days of irrigation restrictions on average is similar to what we actually achieved in the 14-15 dry season, then the impact on our earnings before interest, tax and depreciation, which you probably know is called EBITDA, it would actually be around $1 million per year. And this isn't just 1 year in 10, which probably is the case now, but it's actually a 1 million decrease in EBIT forecast per year. So it actually make us non-viable as a business with insufficient profit to cover our interest in our lease commitments. And the impact of this on asset values and bankability is actually too scary for me to ponder. But given the cost to the wider farming community of the stage 2 minimum flows, I expected that the benefit to aquatic life in the river would have been vastly improved. But I was actually amazed to find when I read that Dr. Ryder's submission against the stage 2, that the increased benefits, there's only, quoting from his submission, that there's some gains from some aquatic species and losses for others. So I guess this is the crux of what you as commissioners will need to assess. Where is the balance best to lie between the brutal impact these stage 2 impacts would have on farming and the community, and with relatively minor, in my opinion, benefits to aquatic life from stage 2. As farmers, we do have a real responsibility to reduce our environmental footprint. And you know, I'm an investor in land and a farmer, and I'm very disappointed to read in Dr. Ryder's submission that the nitrate levels are elevated in the upper Opahi River, but also note he doesn't believe that this is related to minimum flow management. And I want to assure you, I'm sure you hear this frequently, but the majority of farmers now recognise the impact that the management systems are having on water quality and the urgent need to improve practices in this area. And I've actually personally seen considerable change in farming attitudes and practices over probably the last 10 years, but particularly so in the last 5 years. And I do believe that the improvements in water quality will start to come through from these management system changes. And I also believe that water quality improvement will also speed up now with all farmers having to come on board to meet their obligations under the new National Environment Standards for freshwater. This is a good thing and very positive for the water quality in the upper Opahi River. On our business in Wainono, some of the management practices and technologies we've invested over the past few years, which will and are leading to significant improvement in water quality, have been things such as developing a wetland of around somewhere between 5 and 6 hectares, which we've fully planted in natives, and all the water that exits off our farm, because Wainono means oozing water, and a lot of the water, well, all the water, flows through one point in the farm, so it all now flows through that wetland. And the theory is, the science shows us, it will help it be cleansed before it returns to the river. We've also been early adopters of electronic magnetic mapping, which is where you use electronic signals to measure the depth of soil, and then we've ground truthed that to work out the water holding capacity of that soil. And that combined with moisture monitoring technology, and variable rate systems in our pivots, we have every 10-metre zone is quite different on our farm, and we apply the amount of water that 10-metre zone requires. And some of the gains from trials we've run are significant, not only in water use, but also we know now not to put too much water on our light soils, because our data showed us that it was actually flowing through our light soils, and when water flows through, nutrients also flow through. We've also significantly improved our wintering practices, and we've used a lot of fodder beet now that has lower nitrate levels than this kale, and we're also considering the role that standoff pads may have in our business to further reduce nutrient losses. We've been using for a number of years plantain or ecotane in all our pasture mixes, which has been proven to overall reduce nitrate losses off our property of 10%, but in the urine patches of 50% reduction in nitrate losses. And interesting, over the last few years, we've also dropped our stocking rate by about 5%, and we've reduced our purchase supplements by 20%, all around our modelling on how we can drive our nitrate losses off our property lower. The other things I know we just constantly keep doing is investing about 30,000 a year in riparian planting, so planting through our drains, which has also helped cleanse our water and help our aquatic life by the water temperatures being a bit cooler. So we've been water sampling on our property for the last 8 years across 6 different water sources, and measuring the quality of the water coming onto and leaving the farm, and also in our tile drains. And we've got the evidence to show that we know from E. coli and phosphate water quality is improving while it's on our farm. Nitrates, we are elevating the test levels as it goes through our property. We have definitely reduced in the last 3 years, and our goal now is to see how we can actually even cleanse that water as it goes through, particularly with our wetland system we've developed. But I think we also need to keep working together as a catchment so we can learn from each other and enhance water quality across the whole upper Opahi catchment. So all this takes a significant financial investment and is obviously only possible if we have profitable and resilient farming businesses that we're leveraging on. So I guess to conclude, the message I want to leave you is, in my opinion, we are making progress. and I believe we'll make far more progress around improving water quality and enhancing aquatic life in our catchment by adopting the stage 1 minimum flows, compared to the other alternative of adopting stage 2 minimum flows and destroying business to the level that we can't invest in the technology and the management systems and the plantings that we know will improve water quality. I think we all share the same goal, but we've just got different views on the pathway to get there. So that's my story, and I thank you for listening.
Well, it was very easy to listen to it, Mr. Green. It was well presented. Thank you. Any questions, Commissioner Van Voorthuizen?
No questions. The only question I did have in my mind you've answered, and that was whether you were opposed to the step 1 and the step 2 minimum flow changes in table 14P, or just the step 2, and you've clarified that you live with step 1 and it's step 2 that's the problem for you. So yeah, that's all I needed to ask, but thank you.
Commissioner Sullivan?
No, I have no questions either, thank you.
Well, Mr. Green, it's a presentation that shows that you clearly understand all of the issues and you've addressed them attractively, if I might say so.
Thank you.
You've dealt with the realities and you've shown that you're already into the technical advances that we're all hoping will make things better. So we thank you very much for coming in. We're glad you did so, and thank you for your submission.
Thank you very much.
Now, are you Mr. Smith?
I am.
Well, welcome, Mr. Smith. Thank you for coming. So you're going to speak to us about the Cascade Creek submission?
Yes, I am.
We have your evidence statement and we have your supplementary images that you sent in. Thank you for that. Just give me a moment to bring them up. Now, you've got a different angle on these things from the previous witnesses.
Yes, I certainly have.
Very welcome to us. So if you'd just like to present it however you'd like, we were interested in what you've got to tell us.
Thank you. Firstly, good afternoon. My name's Ron Smith and I'm here on behalf of my family in respect to my submission on Plan Change 7 and in particular the minimum flows that are sought affecting the South Opuha River. My submission is more of personal statements and that the effects of the change, and it's certainly not a technical submission today. As you will have read in my earlier submissions, I'm not from the Ashwick area where our farms are, and I've lived here in Christchurch all my life. I was originally heavily involved in the technology sector and subsequently found myself involved in farming through rather unfortunate circumstances. After initially planning to commute to Fairlie for a year, complete the job and then move on, well, 25 years later, I now find myself here not only out of concern for the viability of our family operation, the impact the changes would have on the Fairlie community as a whole, but also for my daughter and my son-in-law and my grandchildren who live on our family-owned properties in Ashwick Flat. Coming from a completely different sector, I was able to bring new ideas to the farming industry. And through such ideas and investment, I've seen the township of Fairlie and its surrounds flourish through the growth of farming. When I went there, the place was dying, to be honest. It was only relying on a very struggling sheep industry, mostly. But things changed, and I can recall talking to the principal of the local primary school, and after about 8 years he said to me, he said, "Ron, you know, you have added one class at our primary school and you don't believe how important that is." That's what happens when more intensive dairying takes place. The investments made by the South Opua catchment farmers, individually and as a group, were based on the terms of water consents that were tested and agreed between ourselves and the other stakeholders, Department of Conservation, Fish and Game, New Zealand Forest and Bird, Environment Canterbury, and many other stakeholders. These consents were designed to stand the test of time, and I vividly remember speaking to ECAN because I was unfamiliar with the consenting issues involved with farming, and I asked them what the expiry dates are put on the consents and are they renewed, because it was a concern for me knowing the investments that were to be made. And the answer back then, it was, I vividly remember, they said yes, they are renewed so long as the consent's been used according to the conditions. But now, with the proposed changes, it makes a bit of a mockery of those earlier statements, I feel. For a party to change terms, which will have huge financial implications on others, doesn't bode well for any future investments in infrastructure throughout New Zealand. Investments in ventures that require large amounts of private capital would come to an absolute standstill if terms can change at the whim of another party. It makes for a very dangerous investment scenario. From my experience, all the farmers in the area, they share a passion for reinvestment in their homes and their farms, and at the heart of this lies the health of their resources, their land, and in our case, the South Opua River. Make no mistake, the care and reinvestment of these farms would be completely out of reach without a profitable operation. And what step 2 shows is that the promoters of these changes, that the interventionists are oblivious to and misunderstand the possible scenario which will eventuate if the proposed changes are implemented. Farming seems to be the conscience factor of Aucklanders and city people, that through the strength of their numbers and the power their voices have, they change things in the rural sector. And it makes them feel that all of their pollution and environmental damage that the cities and their people do to the environment make the changes in the farming sector, and it sort of mitigates what they do wrong in the cities, and gives them an environmental leave pass, really, in my opinion. Many of these people think that by locking up farmlands, it compensates for those city and urban activities polluting the environment. I think it would be benefit for all concerned if many of the city folk spent more time and more meaningful time in the rural community to understand how it works. The gets back to Fairlie and the future of Ashwick Flat, where we are. I've just recently returned from cycling the full length of Westland, from actually about 860 kilometres, and when you're biking at 10, 15, 20 kilometres an hour, you see the land in a lot different way than you see it driving through at 100 kilometres an hour. And I was Well, I was shocked. It appeared to me the whole area is broken down and from an economic perspective, including agriculture, with the exception of dairy farming. You know, not to mention the changes to forestry, coal mining, gold mining, fishing and tourism. And in those pictures I sent you, and it's something I saw when I was away, that I was standing in the middle of the road, probably getting my breath back, and I looked on one side of the road and I saw a dairy farm that was profitable. The pastures were in good condition, the fences were good, the waterways were fenced off. And on the other side of the road, there was a complete lack of investment because there were sheep there was gorse, there was broom, and the sheep that I mentioned were certainly in not very good condition at all. And it just showed to me that without other jobs in these rural areas, they can't fund marginal business practices. Yes, dairy can stand up on its own, but these other farming practices need that support. And in these smaller areas, they do in fact need alternative income. There's been, as we all know, there's been a lot of departmental interference on the West Coast, and it limits the free enterprise. And you can see by those photos of boarded up shops, wrecked homes, things lying everywhere, because there's not a lot of pride in the area, which is, it's contrary to that with what we see in Ashwick, Flat and Fairley. I have a genuine feeling that for Fairley and the Ashwick, that step 2 flows will cause similar impacts and possibly take the township back to the days of those financially constrained activities that we saw more than 25 years ago. It's not a result that anybody wants for our rural towns, really, especially at a time when we're trying to heal the urban and rural divide, which we hear about, and when you read and watch television news items, we often experience the bad things that happen in the country, and they seem to be accentuated. And we want to encourage the local investment, and we need it, and not to mention the recovery of the job markets in these areas where tourism may have been, and that's been affected by this COVID-19 situation. Basically, the bottom line is that in such reductions in the minimum flows will have an adverse effect on the viability of the existing farms, and I think this is undeniable, as you've heard from other presenters. In addition, New Zealand has one unique advantage, I think, that we do make use of at the moment, but we've got to be careful that we look after it. And that advantage is that it's a hospitable and profitable environment to grow food. And it's something we need. We might be able to do without communication, we might be able to do without travel, but we sure as heck cannot do without food, and that's something New Zealand does so well. Tourism was something we did have as an advantage, but look what's happened in the last 12 months. Again, back to food, which we require. No other industry has these advantages. Furthermore, I'm real concerned that you as commissioners have to make decisions which potentially could have a disastrous effect on us. And it would be an extremely tough position to be in what you're in. And not only is it in Fairley, but particularly to me, it's the Fairley community that is important. And the well-being of the people there. And as a result, all of our families in the area. A further point I'd like you to consider is what the current flows do to allow the community to prosper. And conversely, the cost and implications that the proposed changes could bring about. This was detailed in my submission, and it's a point I believe many before me have raised also. From evidence put forward by Opua Water, and in particular their expert Greg Ryder, and on-site observation, the South Opua River is in a very healthy position, with trout and game numbers having increased remarkably since we commenced irrigation, which was at the time the Opua Dam was commissioned. really, why is change needed? Again, I come back to the question, why doesn't Environment Canterbury promote profitability in a community instead of what seems regularly putting roadblocks in the way that prevent it? I know approximately the amounts of funds that have been invested in our catchment by local farmers, and to decimate that, which is what step 2 changes will do, will have terrible consequences, not only financially but to personal well-being and mental health. Who knows, suicide, whatever. When people are under financial strain, what happens? I do hope that you'll bear in mind all of these things when reaching a decision. To finalise, all I ask is my concerns are considered when you deliberate the issues that you have to. Thank you very much.
Any questions of Mr. Smith, Commissioner Van Voorthuizen?
Mr. Smith, no, the only thing I wanted to clarify with you was that in terms of the minimum flow regime for the South Opura was the Flow and Allocation Working Party's 2025 Step 1 minimum flow uplifts that you could live with, and it was the 2030 Step 2 ones that were of concern. So a similar question to the previous submitter, but I think that's the case, is it?
Can I say I'm pretty sure it is?
Yeah.
Because the technical issues
Yeah.
I've left to the people that
Absolutely.
know and on the farm.
No, that's fine. Thank you. No further
Mr.
questions.
Sullivan?
No, I have no questions, thank you.
As you say, Mr. Smith, you're raising issues that many have already, but you've brought a different viewpoint. You've been able to bring some light humour to express what are serious issues, and your photographs have been a great help to your presentation as well. So we do thank you for taking the trouble to come in and present in an interesting way on these important points. Thank you very much.
Thank you very much for listening to me.
Now, is the next submitter Silvercrest Farms, or are they this afternoon?
They're this afternoon.
All right, so we've done enough for the morning.
Yes.
We'll adjourn now and resume at 2 o'clock.